Hello, everybody. Welcome to Boston Indies, Boston's home for independent games since 2009. I still don't have my notebook that tells me how to run announcements here, so forgive me as I stumble through things. If anybody has an announcement they would like to make, please line up, I don't know, here, I guess. If you have an event that you're trying to promote that is games adjacent, if you have a game that came out recently that you want to give a shout out, if you are hiring for a job in the video game industry, yeah, that one gets a laugh for sure. Yeah, please feel free to line up, and I will announce some other stuff. Boston Indies is running coffee hours every Friday morning at 8:30. Chris back there is helping run those. Thank you, Chris. Yeah, just hang out for about an hour on Friday mornings, chit chat about what you're working on, or share what you're up to. Pretty casual little thing. We're running that on the Slack, which is at slack.bostongamedev.org. What else we got going on? Instead of a traditional Boston Indies next month, we're going to have a holiday party on December 14th, and that's at the. Does anyone know? Sorry, it's at the VFW in Davis, like the Dillboy Outpost or something, I think. Anyway, go to the meetup page, meetup.com/BostonGameDev has the specifics there. What else is going on? I feel like I had another one. Oh, we just locked in. We're going to run Global Game Jam at Foundry in Kendall in January, so that's pretty exciting. I don't have any additional details about that, but we had the meeting about it today, and it was pretty exciting. So thank you, Scott, who's running that. I think that's all I got. Here, Jay, take it away.
I got a few events that I know that are happening around. Boston Postmortem is hosting a postmortem for Super Raft Together on their Discord tomorrow on Tuesday around 7 p.m. And then on December 7th to 8th, Sunday to Saturday, there is MICE, the Massachusetts Independent Comics Expo, happening in Boston University. And last but not least, Boston Fig is happening on December 15th at Cyclorama in Boston.
Yeah, round of applause. MICE is really sick. I highly recommend going to MICE. I mean, BFig also obviously great, but we already know about that one. So, oh yeah, what do you got?
Also, I'm putting together a PAX East booth for the Boston Game Dev community, along with several other folks. If anyone's interested, feel free to hit me up and ask about it if you want to show off a game there.
Thank you, Jay. All right, I have a couple other ones that I just remembered. Tectonica by Firehose Games just came out on the 7th. So if you're into factory builders and conveyor belts and that kind of stuff, check it out. It's on Steam, Epic, and Xbox, I believe. And also, we're going to be our next event is going to be a demo night in January. I think it's on January 18th at Aeronaut in Somerville. And I think that's it for announcements. Boston Indies is committed to creating a safe environment for everybody. So by attending, you agree to adhere to our code of conduct, which is visible at the event posting for this event on the meetup page. And yeah, I think that's going to do it. Follow Boston Indies on all the social medias. We're actually using Blue Sky now. I guess Blue Sky it seems like it caught on like this week. So check out Boston Indies on Blue Sky. Yeah, we did it. All right. And after this, we will adjourn to Flat Top Johnny's to play some pinball and have a beer or some hot dogs or whatever. So hope to see everybody there. That'll be whenever the talk wraps up, probably like 8:30ish, something like that. But without further ado, I'm going to let Chris take it away here.
Thank you, Chris. Guess I don't need this because I'm all hooked up. Great to see you all. Great to be here to present to you. For those of you who don't know, the reason why I know Chris Mayer is helped Chris set up the 501c3 exemption for Boston Game Dev Inc., which I'm very happy about. And I'm very excited just to be here today to share some of my knowledge that hopefully will be useful to you. Played games for a long time, like I'm sure many of you, and it's a very good feeling to me to be able to take what I actually do day to day and share it with the folks that make games. All right. And, maybe we should all do introductions for all of us. And also to give a little bit more of my background, I'm a tax attorney. A lot of my work are in mergers and acquisitions transactions. I assist people with selling businesses and buying businesses. I also work on joint venture agreements, and I also work on debt agreements, like representing big banks on loans. And this is my colleague Ian.
My name is Ian Mahoney. Thanks, Ted. No problem. Make sure I turn on the technology. And I'm an intellectual property attorney. I do transactional IP. I also do some dispute resolution, so I'll be talking about some intellectual property issues.
And I'm Ted Hanselman. I'm a corporate transactional attorney. I usually work with startup companies, so emerging companies, help them through all different phases, formation, venture capital raises, debt raises, all sorts, different types of transactions, and hopefully an exit at the end. So, and again, I'm based out of Boston, so a lot of my clients are technology based. It's just, that's what we got here. So, and I'm also wearing a button down. We really set the tone, didn't we?
Actually, this morning, Ted and I were both wearing pink shirts, and we said, uh-oh, that's too much.
And we are the only button downs. Nice.
Yeah.
All right, well, now to get into the really exciting part of the presentation. So tax classification for closely held businesses. So you have different options for tax classification depending on which type of legal entity you choose. If you form a state law corporation, which is any entity that ends in like incorporated at the end, it's going to default to treatment as a C corporation, which means I'll get into the differences in the next slide. Something else that you can do with an entity that can be treated as a corporation is you can do what's called making an S election and treat it as an S corporation. At a high level, S corporations are more pass-through, C corporations are more separate taxpayers. If you form a limited liability company, you actually have more options for how you're classified. You can still be a corporation, but you will default to be treated as either a disregarded entity or a partnership based on your number of owners. And if you're a single owner that owns an LLC, for income tax purposes, it's basically as if you are directly holding all of the assets held by the LLC. If you have more than one owner, then you have a partnership and you have entity level reporting and entity level accounting, but it's still pass-through. But there are differences in how a partnership is a pass-through for income tax and how an S corporation is pass-through for income tax. To make an election, to choose your classification to be a corporation, which is contrary to your default treatment as a limited liability company, you file a specific form called a Form 8832. You obtain what's called an employer identification number through an online portal. It's very easy, and you can make that type of classification election to be treated as a corporation retroactive up to 75 days. And Ted, feel free to jump in about, I know you mentioned you might jump in for legal entities.
I will, yeah.
Sounds good. Okay, what is the difference? So as I mentioned, both partnerships and S corporations are pass-through entities. That means that income and loss generated by the entity is passed through to the owners on a current basis. And then the owners are the ones that pay tax on all the income that is passed through. And that tax is due whether or not you actually make distributions for your entity. So a lot of times, contractually, you include in the entity agreement, hey, you at least need to distribute enough to pay our taxes, because otherwise that's tough to go out of pocket to pay taxes just because you own this legal entity that's generating value but not distributing any of that value in the form of cash to let you actually pay the tax. A C corporation is different. It pays tax separately as its own person, and it's specifically income tax. Owners of a C corporation are not subject to tax unless distributions are made out of earnings and profits. So the corporation both has to have positive earnings and profits, and then it needs to make a distribution. Otherwise, you own stock in a C corporation, you're not paying any taxes yourself. The C corporation has to pay it, but you yourself are not. Something else that's different for a C corporation is that there's a single tax rate. When you're an individual, including an individual that's getting income passed through to you because you own an interest in a partnership or an S corporation, there's a huge difference in the type of income and the rates that you get taxed on that income. Ordinary income can be taxed up to 37%. Capital gains can be taxed as low as 20%. So, almost double. And, that is a significant difference, and that is something that comes up, and particularly when you sell a business and you're generating a huge amount of income. In that scenario, you want to maximize, of course, the treatment of that income as capital gain.
It's actually fascinating that it has changed to what is the preferred model over the years. Back in the day, everyone was a C Corp. That was just kind of what you were. LLCs didn't even exist. The only people who did partnerships were real estate holding companies. And so everything was a C Corp, and you paid the double tax, and you just took it in the neck, and that was life. But then LLCs popped up, and suddenly people started doing LLCs. That became more flexible. People liked the single level of tax. They liked in some respects, they liked the flexibility of the LLCs. But then there were some downsides to LLCs, and people realized, like the pass-through taxation, the mandatory tax distributions, there's some problems with how you pay founders. And on top of that, it's a little more complex, and it's a little harder to sell sometimes to employees. C corporations, you just give stock options. Everyone knows what stock options are. LLCs, the problem there is you get stuck with profits interests, and everyone here knows what an option is. I don't know how many people know what a profits interest is. Yeah, so it's harder to sell that to employees. So that got to be problematic. And plus, there's some recent developments, well, actually old developments, but there are some advantageous things going on with C corps now. So we see a lot more C corps popping up. There's also a question of who your investors might be.
Right, like in the startup space, I've heard that C corporations can be attractive, particularly when you're getting minority investor fundraising. You're not getting bought out completely, you just are getting kind of angel investors, a little bit of money. Sometimes the C corporation simplicity is good for those type of investors because they just really see it as rolling the dice. It's not the same as a buyout scenario, and not having the pass-through taxation gives them some simplicity. And it makes it a little easier.
It's very simple. The nice thing about a corporation is you basically say, I'm a corporation, and there's a whole section of law that says what shareholders' rights are, what directors' rights are, what all the officers' rights and obligations. And so it's really simple. You check a box, I'm a C Corp, and you buy into this whole organizational structure. LLCs, the joy of them is they're super flexible, which is there is no organizational structure. It is what your operating agreement, which is a contract you've developed, says is your structure. So they're infinite. The best thing about LLCs is they're infinitely flexible. The horrible thing about LLCs is they're infinitely flexible. And you have to do these entities, you have to draft up a whole agreement between the parties. And so it can be it's more flexible, but it can be more expensive. Plus, there is some issues. Some investors are less likely to want to invest in LLCs. Some investors, that used to be a big problem originally. It became less of a problem, and now there are ways around it, but a lot of investors they don't like the pass-through tax problems, especially if they have any foreign investors. That again becomes problematic. So sometimes a C corporation, even with the double tax, makes sense. If you would say, geez, why would I expose myself to double tax? The answer is simplicity and attracting investors. But
yeah. Thanks, Ted. So this is just picking up on some of the things that Ted was just talking about. But you can be very flexible in how you chop up economics with an entity that's taxed as a partnership as a tax matter, and as a corporate law matter, a limited liability company. There's just more flexibility for just building into an operating agreement, things like preferred returns, hurdles, promotes. You can really chop it up in a lot of different ways. And that is different, from example, as compared to an S corporation. An S corporation has very strict rules. It is passed through taxation like a partnership, but you can only have pro rata sharing of the economics. You cannot have preferred returns. You cannot have priority returns. Everything has to be pro rata. So it's limiting in that way. You can have differences in voting rights, but that's basically it.
It means S corporations are very attractive to closely held family businesses,
yep.
But investors don't usually like S corps because they want their priority return. They want a preference.
Yep, that's right. I have to say that Still, the vast majority of founder-owned businesses that have remained founder-owned prior to being sold when I have come into the picture to help them out have been S corporations, because it gives the mix of the simplicity with still the pass-through taxation and not having multiple layers of taxation. Something else that to keep in mind is you have more flexibility in ownership. When you have a C corporation or a partnership as compared to an S corporation. S corporations generally need to have individuals as owners or certain types of special trusts. Your third-party investors are probably not going to be, in most cases, one of those types of permitted S corporation owners. So if you're taking outside investment, it might end up pushing you away from the S corporation classification. You might still be the same type of entity as a legal matter. You might still be an Inc., but you might not be able to maintain your S election if you're taking an outside investment. Why choose S corporation classification? One of the benefits that I mentioned is simplicity. Another big benefit is how employment taxes work a little differently. So everyone's kind of familiar with your income tax, but there's also the other types of taxes that we pay on our W-2 income, like the Medicare taxes, the FICA taxes. There's like an extra few percent of taxes, and then you're not subject to the tax when you get to a certain income level like 180K, but then certain taxes you're still subject to it no matter how much you make. And people don't focus too much on those type of taxes, but or at least to start until you end up in this world. There's a big difference in that when you are an owner in a partnership and you're active in managing the partnership, generally all of the income that's passed through to you can be treated as self-employment income and subject to all of those taxes that you have to pay on all of the income. When you own an interest in an S corporation, you have to be paid reasonable compensation. So you have to pay yourself a fair salary that a third party would be paid, but that's it. It's not all of the income that's passed through to you that's subject to employment tax. So that alone could save you taxes by doing an S corporation as opposed to a partnership, because you're probably going to be involved in managing your own legal entity that you're setting up to run your business. Something else that's nice about an S corporation, you have flexibility to sell that entity in two different ways. You can just sell the stock of the entity, and it'll be treated as capital gain completely, or you can do an asset sale structure. And an asset sale structure can still give you largely the same result because there's only one layer of tax, and your self-generated goodwill, which is usually the majority of the value that gets ascribed to your business in a sale, can be subject to the same capital gain treatment. And in addition, because there's optionality for an S corporation, sometimes a purchaser will pay you the difference in taxes to make you whole. And also it's very attractive to the purchaser because they want the step up in basis. They want to have asset sale treatment. It gives them depreciation deductions to reduce their post-closing taxable income after they've acquired your business. So having that optionality might mean that you get put in the same place as if you had complete capital gain. If you own an entity taxed as a partnership and you're selling it to a third party, you don't have an option. It's going to be asset sale treatment to you, which means still largely capital gain on goodwill, but there will be other ordinary income that you'll recognize. There's no optionality, so a purchaser is not going to make you whole. There's no other way for you to sell your business to them. So C corporation taxation, we've already talked a little bit about this. Something else that I just want to mention is that there's this super favorable taxing regime called qualified small business stock. And
Which has been around for a gazillion years.
It has been around for a gazillion years.
And yet no one really used it until...
Like 10 years ago?
Yeah.
Well, it got a little more generous around like 2010, 2012. Used to be like excluding like half of your capital gain income, but it gradually got to excluding 100% of your income. So this, if you jump through all the hoops correctly, you can form your business, sell it, and not pay income tax, not even pay the 20% tax, which can be incredibly favorable. And This can be a large amount of money too, because what you're basically limited is like the limit on your exemption is the greater of 10 million or 10 times the adjusted basis of your stock. And then there's separate requirements. You need to basically, the business needs to not exceed $50 million in value. You need to hold the stock for 5 years.
That may be the biggest issue.
Yeah, holding it for 5 years, and also keeping it kind of in the same structure that entire time.
But this is a selling point for investors. Again, like even 5 years ago, I didn't really hear investors really pushing it, but founders and investors now are really focused on this. So they may go the C Corp route, thinking this is an exit. Now, the problem is it does restrict you on your exit, so it's not as easy as people think. But it's a driving factor.
Yes, it's also known though in the field, in the market, people know about this. So if you come into a buyer and say, hey, we did qualified small business stock planning. We need to do it this way because we've been planning this for 5 years. They're going to understand it because they're used to seeing that type of planning, and they're probably going to help facilitate it. And if you attract third-party investors to put money into your company because you're trying to set this up, again, you could have serious value being exempted because you look at the $50 million value, right? Imagine if you put $45 million into a new company. Still not worth $50 million, right? And then you get to exempt 10 times $45 million. So you sell it for $450 million and you don't pay tax on that? It's not a bad deal.
Yeah, do you want to do it? I'll do a sum up after you've been through, so keep on going.
Okay, sounds good. You can also mix and match these types of structures. You can set up an entity, tax as a partnership, and then you can have separate S corporation holdcos. That allows you to have this super flexible sharing of the economics while still allowing each of the owners to be W-2 employees of the lower tier entity, which can also matter for like employment plans, or benefit plans like cafeteria health plans. You need to have W-2 employees to have cafeteria health plans, and it's difficult to be a quote unquote W-2 employee when you're an owner in entity tax as a partnership. Cafeteria health plan is like choosing your insurance when you work for a company, and they'll have like several options for you to choose, like a high deductible option, a PPO option. That is your cafeteria health plan, and that can only be made available to W-2 employees. Here's just another mix and match example where you have a entity tax as a partnership above an entity tax as a C corporation. So here you don't have pass-through taxation, but you are still building in that super flexible sharing of the economics where you can just put everything into an operating agreement and have preferred return and priority return and stuff like that, and not be limited to kind of the more plain vanilla options and trying to do that in a corporate entity, which is just going to be more complicated to try and structure and get to the same place.
So one of the questions is, okay, 3 different options. How do you choose? If you listen to the tax folks, they may push you in one direction. If you listen to, what you really need to do is look at your corporation, look at your organization, and get a sense of, get out your crystal ball and guess what your future is going to look like. Am I going to flip this in under 5 years? Am I going to take private equity or venture capital investors? Do I want loss? Will I have losses early on? So you try and get in your crystal ball and guess how long you're going to be around, what's your exit, what's your model, and then try and best guess, pick one of the ones that fits. Okay, I'm going to have a lot of employees. I'm going to want to do stock options because that sells. So I'm going to do a C Corp. I think I'm going to have an investor. But I'm going to definitely, it's going to take at least 6 years for me to develop this product and for a flip. So the 5 years is not an issue. So I'll do C Corp. Or no, this is going to be a short-term thing. I want to flip it right away. I'm not taking investors. It's just going to be me. I'll have losses in the first year. I'm not an expert on losses, but pass-through is kind of nice on that. And then I'm going to flip it in a year. Okay, maybe I'll go for an LLC on that one because I don't have the employee issues or the investor issues. So it is kind of as best you can guess, which is pretty hard. I mean, the number of companies I've set up, oh, we're going to be a C Corp, oh crud, now we're not, now we wish we weren't. Or, oh gosh, we're an LLC or an S Corp, and then we do an F reorg and change it. Yeah.
I guess that was part of my question. So if a company doesn't foresee either in the foreseeable future, acquisition, investors, employees, is it viable to just start an LLC for like the flexibility, and at some point in the future, if those become an issue, restructure, or is that like wishful thinking, out of question, not really realistic?
You could do that, and it's not unheard of. Whenever you do a restructuring, you have to kind of walk carefully because you want to make sure not to trigger your built-in gain when you're not being paid cash for the current value of your business. But in a lot of circumstances, it's something that can be done, but it's not certainly going to be easy or not trigger that tax. But there are situations where it can work.
I mean, generally speaking, the IRS doesn't mind it when you go from a single level of tax, like an LLC or an S Corp, to a C Corp. And so there are ways to do that. If you want to voluntarily have a double level of tax, the IRS generally is okay with that. So going that way is easier than going from a C Corp to an LLC or an S Corp. That's a lot harder. So going backwards is hard. That being said, I just went through a reorg of an LLC turning into a C Corp, and it's still a pain in the neck because we had a big, huge operating agreement with all sorts of different waterfalls, and then I had to recreate all those waterfalls in that LLC agreement, from the LLC agreement, in a corporate, articles organization with a preferred stock and all that thing, and we had to have 32 shareholders sign off and agree to it. So it still was a bump in the road, but it was generally doable.
Yeah.
Sorry, another one.
Yeah. To go with that, this might be complicated. When going from a C Corp to an LLC, is some of the reason because of just the large number? Would it be something like, a lot of people want to leave the company for one reason, and then just one or two people left?
I rarely go from a C to an LLC.
You trigger, it's hard to get out of the tax in that scenario, at least on the tax side.
The IRS basically says all the value in the C Corp, that would have been double taxed, and so we're going to figure out a way to make sure it still is double taxed.
Yep.
And so you can't just switch it and say, oh, now I'm a single tax. All the built-in gain, or I'm using probably the wrong term.
Right. No, that's right.
The IRS has all these perverse rules to try and capture that. So it gets complex going that way.
And again, a lot of folks end up with S corporation because it pass through, but some simplicity.
I've heard that there's a difference between what you form as a legal entity and how you are taxed.
That's right.
And that you can elect a different form of taxation.
That's right.
Can you talk a little bit about that?
Yes.
In general?
Yes. I mean, in LLC, you can be taxed as a corporation. Including an S corporation, you have to make an election on something called a Form 8832. And a corporation, it's referred to as a state law corporation because each state has their rules for the corporate law form. So basically anything ending in an Inc. at the end, that cannot be taxed as a partnership, but it can only be an S or a C Corp, basically.
So like an LLC can be taxed as an S Corp or a C Corp perhaps?
Mm-hmm. Yes.
You just can't do the opposite, have a C Corp taxed as an LLC?
You can't have a state law corporation taxed as a partnership for income tax.
So C Corp is a tax moniker. It's not you form as a corporation, then you elect to be an S or a C.
Okay.
Is that?
That's right. That's right.
Why might you want to form like an LLC and get taxed as a different form of corporation versus get taxed as a corporation and get taxed as a C Corp or an S Corp?
Well, I mean, they're really trade-offs, and I mean, even if you are forming as a state law corporation, and you're doing a reorganization, you can still do a merger of that entity into an LLC with a limited liability company surviving. One way you might start with a limited liability company to start is because maybe you don't know where the future will hold. But the reality is that if you really want to make that type of change, again, you could probably do some type of merger or conversion structure. So you don't necessarily need to start out as an LLC. One reason why I see people do state law corporation is because they're worried that they're going to mess up the election. They're worried that form that gets sent in the mail is not going to get to the right place, or there's going to be somebody at the IRS that just doesn't answer it. and you don't have the tax profile you're looking for. But that also should really be able to be addressed. You should be able to follow up.
It's very rare to see an LLC taxed as a C corp.
Sure.
I mean, is that a fair? For me, I see LLCs taxed as S corps.
Yeah.
But I tend not to see. Maybe I'm just
it's rare.
narrow.
It's rare. I agree.
Yeah.
Yeah, it's rare. Yeah, it's rare. All right, and I mean, there's some cool, like the qualified small business stock. Very cool, right? Very exciting. But you might not know that you're going to sell your business in 5 years for a bunch of money, and maybe S corp just works, because it's simpler and you have your single layer of tax. But there's trade-offs.
Can I just make sure I have this correctly? So there's basically 2 ways you can form, correct me if I'm wrong, an LLC or a state corp, and there's 3 ways you can get taxed, and you kind of choose with a couple limitations which of those structures you want to be in.
Yeah.
It can also be a limited partnership, but we're not covering that because
That's
no one does that.
That's
That's
right.
only for real estate.
And I see some folks like filming. We're actually going to probably share this presentation in full afterwards, so you guys can rewatch it, however much you want.
Hours and hours of entertainment.
So something else I just want to flag, a few other quick things before I pass it off to Ian.
Worse with insomnia.
Something to think about that I see a lot of startup businesses not focus on is compensatory equity. You want to give equity to your co-founders. Maybe they weren't with you at the very, very start of the business, but they've become important to your business, so you're giving them a share of the company. Those rules are very complicated, and it can be easy to be in a situation where you're not treated as taking into account all of your ordinary income as compensation from receiving that interest. In my world, usually it's better off for a company or any business when they want to issue equity to people that work for that business to have it included to them right away, because that business is not worth as much at the time. It's small, very closely held, hard to ascribe any value to that interest. What you don't want is a situation where you're about to sell your business and all of your important managers that you have given equity and tried to make a partner and co-owner with you is suddenly going to get hit with ordinary income instead of capital gain on that sale transaction because they didn't do the right structuring of how that interest is issued to make sure that they're treated as whatever compensation they received, it's on the day that they receive that interest, not in a year, not in 5 years from now. And there's a few ways that you can make that happen. One way is what's called a Section 83B election, which essentially says no matter what the rules are by default, I want to treat it as included to me today. There might be forfeiture, there might be an ability to forfeit my rights to this stock. That's okay, I'm going to include it today. If I get hit with income and then I lose the equity later, I'll try and claim a loss later. And usually you're ascribing a very small value at this point. And there's even specific rules and safe harbors that you can use to even feel better about the value that you subscribe. I mentioned something called a non-lapse restriction, which is a very technical set of rules. But this is just something that I suggest thinking about and maybe getting some advice on if you're at this stage, because it is something that I see come up a lot in a sale context.
And if you're an employee and you get stock options and they have a little form 83B attached, file it.
Yeah.
Don't ignore that form. That's an important thing. A lot of times it just goes out, and some corporations are religious and they follow up their employees and make sure it gets filed. But if you do get an 83B election on your option, please file it. It's the right thing. Sorry.
So it sounds like for a lot of these different options, you've been discussing it from the angle of, how and when you're planning on selling it. If either selling isn't in the immediate forefront or there's other things that you want to do with it, are there reasons to choose one style over another?
I mean, if you're not gonna, again, I think there's a reason why I see a lot of founder-owned businesses choose an S corporation, because you don't have the complexity of an operating agreement for an entity tax as a partnership, and it's both corporate law complexity and tax complexity, but you still have a single layer of taxation and you don't have all your income passed through subject to self-employment tax. So I think there's a few reasons to push you in the S corporation direction, all else equal, even though there are specific reasons why you might want to think about the other one still. And the compensatory hit thing, it's probably still good to think about, because even if you don't sell, you might have the IRS come knocking and say that there was a compensation hit years later, which is not expected. So it might still be something good to think about.
From my perspective, I don't want to speak for everyone. It's why we're here to do this. I made an LLC a year ago because I think that was the right choice. I just want to make a cool game and maybe make a profit on it, and maybe eventually be able to pay people to help me make games in the future. Is that from that, is that enough to choose, or no, I chose the right choice?
The questions we'd ask you: how many? Will you have other employees?
No.
Will you take outside money?
What's that?
Will you take outside funds?
Probably not.
S corp.
Pretty cool. Isn't that kind of the drivers? On a sale, it gives you the most flexibility on a sale.
Well,
if you have losses, they pass through.
Yeah.
So the losses all pass. Yeah, so our income.
So how have you been, do you have other owners of your LLC? Okay. So it's just been a disregarded entity to you then, same as same as if it's not there. It gives you the corporate law protections from liability, but it's basically a nothing to you. From an income tax perspective, whatever income is generated from the assets held by the LLC is just your income.
But just as a warning, don't be too successful. Don't hire people. Just keep it under wraps. Because suddenly you'll get really complex if you start hiring folks and taking outside funds. But then a lot of people think that's what I'm going to do, and then suddenly, oh wow, this is better than I thought.
Well, if I get to that point, is that hard to move that ship?
Well, it can be, there can be complexity to going from a partnership form to an S corporation form. Not that it's impossible, but there can be complexity, and you can end up having a dry tax charge depending on your facts.
But listen, it is a crystal ball or a Ouija board. You're doing the best you can. You can't know today what your needs will be. And so it is an art, not a science. Yep. And all you can do is do your best estimate today. You can't get paralyzed and try and anticipate every twist and turn. Say, okay, this is what I think I'm going to do. Let's go with it. And again, you can get good advice. You can get tax counsel to help you try and solve the problems at a later date. There are ways. It gets more complex. And so I'm a big fan of keeping things simple. Tax folks, they're very creative, and they can make. But there are solutions. Then if you have to get complex, you can get complex. And I use Chris all the time. When someone starts simple and it gets complex, then we get Chris involved. And it does get complex, but it's doable. There are ways. I shouldn't say it's always doable. There are ways to do things. Maybe some compromises here and there, but nothing's. You're not stuck forever and ever. There are some options. Is that a fair statement?
Yeah, just thinking about your deal and ownership and getting that in the right place.
Yeah. So.
Go. Yeah.
So you go over the examples, I think it's very representative of probably a lot of folks here. What is the challenge of bringing employees if you grow to say like a couple people? Presumably they're not co-owners, or presumably they are.
So it depends.
Should be made if you know that's the future, I guess.
Yeah, the complexities are they just going to be? Are they going to be employees? Are they going to be contractors? Are you going to give them equity in the company? So if they're just contractors, then it's not a problem at all. So they're not even employees there. You're just paying for their time. Then you have to talk to Ian to make sure you get to own their intellectual property. But that's fairly simple. But if they become employees, even then it's not the end of the world. It's when you want to start giving equity to folks, and now suddenly they are a member of your LLC. And now you need to have a really long operating agreement for your LLC, which says what happens when they die, what happens if they leave, what happens if they're a bad person or a good person, and so it gets more complex. And then if you want to incentivize them, you can't give them stock options. You have to give them profits interest, which one person in the room knew what a profits interest was. And they're hard to sell. the way my clients, when you're hiring, if giving options in this industry is important to hire people, then it's easier to give options, right? Because that sells more easily. I can sell profits interest, but mostly it's because we tell people that kind of like stock options. So there's a way around it, but it just gets a little more complex.
Employment taxes too.
Yeah.
That is a reason why people go in S corporations, even your single-owned LLC. If you start generating significant income, you might be able to reduce your taxes by just putting it in an S corporation and paying less employment taxes, because that might all be self-employment income to you.
Right. Yeah, I guess like the goal is like, if I'm able to have a gain and have income, I would love to be like hire an artist for $8,000 a year or something to help like generate content.
Sure.
Right.
Yeah. And you can do that in either form. Ultimately, it's mixing ownership and employment where it gets a little more complicated. And I have seen S corporations as single-owned S corporations too. I think it's really that employment tax reason. Yeah.
About the difference between what is it called? Sounds like interest and stock options.
Profits interest. Yeah. So profits interest. Has anybody heard of carried interest? Kind of like private equity or hedge fund guys paying too low tax on the income they're getting from the private equity stuff they manage. That's a profits interest. And basically there were just two pieces of guidance issued by the IRS in like 1993 and 2001 that gives you a safe harbor and allows you to basically issue compensatory equity in a very favorable manner. Where you have a deemed liquidation test, and it basically, you just make sure that person sits behind all the value that exists when they come into the business, and they can put $0 inclusion and basically get equity, get hit with no income when they receive the equity, and then have the gain later, result in capital gain.
So I'll be a tax cretin and
Yeah,
correct me if I'm going. So if I get a stock option, so I'm a C corporation and I give you stock options. But basically that says it's a piece of paper. I'm not a shareholder in the company. You're not a shareholder in the company. All you get is a piece of paper that says you can buy shares in my company at some future date at this fixed price. And in stock options, that fixed price, so if I give you options today, what I do is I look at the value of the company and I see, let's say I'm giving you 10% of the company and the company is worth $10. I need to make sure that the strike price that you're right to buy is at $1, because I issue those options at fair market value, and then it's not taxed to you, it's not taxed to me. Life is good. You don't. If I go out tomorrow and sell the company for $10, you don't see you get nothing, because the $10 is what it was worth when you came in. So you only participate in the appreciation of the value. If I sell for $20, then now you get a buck? You get your 10% of the ups. So stock options, when you get stock options today, there is no value in them. It's only if the company appreciates in value. Profits interests are basically the same thing, which is the LLCs don't have stock, but you get an interest in the company. That's a slightly different by LLCs and pass-through entities, is that you actually become a member of the LLC today. So I'm making you a member. You'll get a K-1 going forward, which may be a little scary for some employees. But the value, the way the operating agreement of the LLC says profits interest only. If I sell for $10, you still get nothing. If I sell for $20, now you get a buck. It's the same concept, which is profits interest only participate over this threshold amount, and the threshold amount is fair market value. So they're very similar. There's some benefits to profits interest because you can actually get long-term capital gains because you're owning an interest right now, so you can actually have a holding period. You start that. With options, you don't start your holding period. But they're very similar, and I can argue that actually profits interests are better. I think tax people would probably argue they're better, but they're harder to sell.
Yeah, I think it's less settled. It's a little more outside the box, even though they are incredibly prevalent. I have some considerations on sale, but I'm just going to flip by those. If we have time later, maybe we can go back. But yes.
So what if instead of selling, per se, you have multiple co-owners, many years down the line, you pass it internally to a regular employee where you just raise them to a owner position? How would that affect equity and other
source that are related to that?
Well, I mean, you are giving a piece of your equity no matter what at the end of the day. And, you know, if you want to get creative with what that equity looks like, you're going to have more creativity in entity tax as a partnership, like a limited liability company. You can get incredibly creative in what type of equity slice you are slicing away. S corporation is going to be a pro rata piece. What % do you want to give?
And you're saying also, like, while you're giving that to like the new owner, but in turn you're also stepping down. How would that affect like yourself as you step down?
Well, I mean, I assume that you would keep your equity unless you're being bought out and just being diluted. I mean, sometimes you see employees get together and buy out original owners, and there are even specific structures that you could do that are good for that, like employee stock ownership plans. And if you go that way and kind of, you know, the employee group kind of gets together, you can even get financing from like a third-party bank because they're used to, you know, giving financing for those type of buyouts. But the more usual way you see somebody give up their founder equity is selling to a third party.
Or just issuing more shares, so it's dilutive. Every time you bring someone in, it's dilutive to the ownership. You know, there's some ways to, you know, LLCs can be more flexible, and I guess C corporations with preferred shares, you can have layers. So, you know, I still get, you know, participate in, you know, the first X dollars is still mine, and then now you guys are only sharing in later amounts. And there are creativities, but the more shares you give away, the less is left for you. Is that? And again, there is no such thing as non-dilutive shares. that doesn't really exist.
Happily pass it over to Ian.
I'll be quick.
Who knew that
That's
tax
right.
would be
So I know. Tax and corporate entities. So a couple of thoughts in terms of the concepts to cover. I'm going to go relatively quickly to try and catch just the big points. So there's a couple of different flavors of intellectual property. So copyrights, trademarks, patents, and trade secrets. I'm just going to talk about really to take a look. So I'm jumping to trade secrets now, and we're going to talk sequentially what you'll need to be thinking about in terms of getting your entity going and capturing the intellectual property assets within that entity nicely. When you're first starting out, you're going to want to think about trade secrets. And essentially what a trade secret is I've told Ted something interesting that other folks don't know, and I've taken steps to make sure he keeps it confidential as well. So the key issue is it's something that's not widely known, and I've taken steps to keep it confidential. So the key item here is a non-disclosure agreement, so an NDA. When you're just starting out your development, you're going to want to put NDAs in place, these non-disclosure agreements, with the other folks on your team. So your co-founders, if you've got some gig workers coming in to help you out, you're going to want to have that non-disclosure agreement in place.
Investors.
Investors, exactly. You want to get the whole team under that nice umbrella. As you go forward, and once your game is out, general availability, you know, other folks are seeing it, that concept, that trade secret concept, isn't going to work for the public-facing components at all. It's out there. It's in the public. There's nothing I can do about it. You're going to then need to turn to copyright. And copyright is protection that it's not based on contract. I don't have to know you at all, but if I have a copyright in this delightful talk and you copy it or you create something substantially similar to it, I can say stop regardless of contract. You can register copyrights. I've put a little bit of information up here about registering copyrights. You don't have to register your copyright if you don't want to. There's an online structure. The form is somewhat complicated, but once you've done it once, it's pretty straightforward, and you don't need counsel to do it. Registering the copyright gives you extra protection in terms of remedies. So you can get these delightful things called statutory damages. You can also get attorney's fees. So,
only a litigator would
yeah, that's
find
right.
that
That's right. But so copyright is what you're going to need to be thinking about once you've released your game. The other thing to be thinking about, I'm not going to talk about patents because I think that's probably something downstream to be thinking about, but is trademarks. So if you're going to brand your game, you don't have to register that particular brand. You don't have to register your trademark. You have, once you've started to use it in commerce, you have what are called common law rights, which essentially give you protection based on your market penetration. However you're going to go forward, if you want to register, you'd need counsel for that, or just rely on these common law rights that arise through use. You're going to want to make sure that you've done some level of search about the particular mark, about the particular brand name. And I've given you a link to the trademark office where you can simply type in the term you're thinking about, and it'll come up with other folks that have registered marks or that have pending applications, or even marks that have lapsed. And that will give you some sense about how much green space there is for this particular name. Now keep in mind too that a brand in one market vertical is not the same as a brand in another. So if you're doing something and Joe's Acme shop is over here with car repair and you've got a delightful game, it's unlikely that there's going to be a likelihood of confusion there.
So just one thing to think about on especially talking about trademarks is how much are you investing in your brand, in that name? So I have some clients who, they're not really outwardly facing, so they could change their name at a drop of a hat. They're not investing it, they're not marketing it. So for them, the trademark's not as important. If you are really trying to develop a brand and you want to use that brand over and over again and you're investing in it, then the trademark becomes more important, and doing a search.
Registering the mark is much more important.
Again, if you're just running a small shop and you're not going to sell, no one cares about the name of your company and you're not investing it in the logo, But if you are building it, that's when you want to do some searches, maybe even hire an attorney to tell you before you invest all. The worst thing in the world is using a logo or a brand that you think you own, that you think is great, and then 3 years from now you get a cease and desist letter from someone else who has a substantially similar in the same market, and they tell you to change it, because then that gets expensive to change.
And those cease and desists are delightful letters to receive.
Again, only a litigator would.
Yes, go ahead.
Do you happen to know the average cost of rebranding?
So a trademark application, it would be, maybe $5,000 to run through. Rebranding really depends on how much you've invested in the goodwill. In other words, if you've got, logos all over the place, you've printed out all sorts of swag, you're going to need to get rid of all that. From
Depends
the
on
trademark.
how far down the road you are.
Exactly.
Early stage, not so hard, right? But if you have Microsoft, it costs a couple bucks for them to rebrand. Smaller shops, not so much.
They can probably afford it. Yeah.
They can probably not.
So one thing to think about is different layers. So there's a photo up here, and the thought is when you're taking inbound content, you're going to want to look to see what kind of cake you have in front of you. So the example here is you can see the paintings in the photo there. That would be one level, so there's a copyright owner of those paintings. Now again, these are, I can't really tell what they are in that picture, but so that would be one level. The next level would be the individuals in the shot. Do you need permissions from them to use them in this particular image? The next layer is the photograph itself, and then the top layer is the slide itself here. So you can see you'd need to clear the rights from each of those levels in order to use this particular slide. And there may be different copyright owners for each of those levels. So take care when you're ingesting content that you've thought about those different structures, those different potential owners. So provenance, and what I mean by provenance is what's the history of the IP? Is the record clear? Will I have a good, clean ownership to the IP? And I'm just going to jump through to this little chart here. And what this is intended to show is all of the different components that can go into your product. So if you take a look at the top right-hand spot, you can see the inputs may be your founders, your employees, your independent contractors, your gig workers. All are going to come into your IP, and that's going to be embodied in your particular game. You may have third parties as well that you're using content from them, or maybe you're using a platform from those third parties. You need to consider those IP rights as well. And you can see those all go into your particular product. Those are all the inbound rights, and you're going to want to make sure you capture those cleanly. Even for investment purposes later, investors are going to be very interested to make sure that the provenance is clean, that you have nice contracts feeding that IP into your product. The next step is outbound. How are you going to license that out? How would you, what are your terms of use in terms of your users, your subscription agreement, those types of contract terms going out? And then, of course, you can see there's the end user at the bottom of the stack.
Provenance really matters if you ever go to sell your company. That's when the investors, they'll go over everything. They'll say, okay, in 5 years ago, you had an independent contractor who, created this section. Where's their assignment of IP? And you're like, I didn't get one signed. And then now you have a hole, IP is like a bucket, and now you have a hole in the bucket and water's starting to leak out. And you're allowed to have a couple of leaks, but if you start having leaks all over the place, that's when investors start to
get very
concerned.
leery. Exactly.
And they will make you go down and chase down that person and try and get an assignment of IP from someone you haven't talked to in 3 years. Good luck on that.
Exactly.
So do it right now, because everyone will sign the assignment today, because there's no value. They want, if you're hiring a contractor, they want the fees for being a contractor. Getting them to sign an assignment of IP 4 years from now is less fun.
Yeah.
What about user-generated content? So like for my game, I'm thinking about allowing players to add their own content to like multiplayer so that other players can play with it.
Perfect. That's an excellent question. In your terms, you'd want to have, and maybe it's just a click-through, but you would want to have some grant to you of those rights. Because once that content gets into your particular game, it's going to be difficult to pull it apart, and the provenance issue will come up. But in your terms, something's relatively straightforward that says, hey, you're going to be providing content, your user-generated content. It's going to be ingested into the game. You grant me, either you could transfer ownership to me, and actually the next slide will talk about that a little bit, or you, user, can grant to me a non-exclusive, worldwide, irreparable, perpetual, royalty-free, paid-up license to do whatever I feel like. And so you can get something very, almost the equivalent of ownership. But that question is spot on. In other words, I apologize. So good question. And again, that is precisely the idea. That's right. So background and foreground IP. This is particularly relevant for inbound, gig work. Are we doing okay in terms of time? Okay, all right. So the idea here, and I'm just going to jump to the little graphic. Chris is going to come and do some development work for me. Now Chris is, the Einstein. And he's got this great toolkit of real cool modules. He's got all sorts of content. And I say, Chris, man, you're going to come work for me. I need to own what you're doing for me. And Chris says, come on, man, I don't want to sell you my toolkit. I can't transfer everything to you because how am I going to go work for Ted coming up? So the solution there is to talk about foreground and background IP. And the idea with background IP is, hey, it's your toolkit. It's what Chris already has. He's already created. This is either independent of this particular agreement with me, or it's something that he's created beforehand. So he's not going to want to transfer ownership of that to me. However, there's foreground IP. This is what I've hired him for. Gee, I need to own that. So a common structure is what I've outlined here. In other words, we've got this intellectual property up top. We're going to divide it into foreground and background. So this is Chris's developer IP. So he's the developer. He's coming to work for me. In the agreement, we'll say, Chris, you can retain ownership of your background IP. You're going to assign the foreground IP to me. For the background IP, you own it, but you grant me this wonderful broad license that's essentially the equivalent of ownership.
Perpetual.
Yeah, perpetual, exactly. You paid up, it's that's right. Transferable. And so that allows Chris to continue to work for other folks. Now, again, he can't give them an exclusive because he's already given me a non-exclusive. So he's sort of given that up. But that's a way to encourage folks to come work for you without telling them, hey, it's either my way or the highway. I want it all. So another thing to be thinking about is, and we've talked about this a little bit, Ted brought it up with, registering, the costs, how much attorney work do we want, particularly if we start talking about a patent portfolio, high expense. How do you want to calibrate your business model with your IP? How much do you want to focus on this? And really the issue there is registration. When we're talking about registered IP, you have to have an attorney, and particularly for a patent portfolio, it's going to be expensive. Registered trademark, we talked about, reasonably expensive. The trademark search is reasonably expensive. But if we talk about copyrights and trade secrets, you can keep that pretty much under control yourself. For registered IP, in terms of investors, that appears on the books. And if we've got a schedule that goes with whatever the various investment agreement, sale agreement, the schedule is going to be able to say, here's the patent that's registered, here's the serial number, here's the trademark that's registered. It's very easy to point out those assets, and it's easier to value those. So there's help there in terms of investment.
And investors generally speaking, historically, registered trademarks and registered patents, those would add value to your sale, because not only do they say you own it, but you can exclude other people from using it. So that tends to, though I'll have to say recently, patents are so expensive that some investors aren't really as excited. They're willing to run with, it depends on how long your technology is good
that's
for.
Right, what industry you're in as well.
Some industries, your technology is obsolete in 2 years anyway. So what the heck? Like I was saying earlier, chip manufacturing, those folks tend not to get exclusive patent rights. They tend to share a lot of their technology, because a lot of their stuff ends up being obsolete in 2 years anyway. So by the time you get the patent, you don't need it.
Yeah, exactly. Yeah, go ahead.
Does the registration price for IP or copyright or trademark change depending on the size of the company or the size of the thing that you're registering, or is it just a fixed flat rate?
It's a great question. For a trademark, it will depend on how complicated the prosecution process is. So maybe someone else will raise an objection, and getting the trademark issued, getting it registered might be expensive. A copyright is at $65 if you fill out the form online and you take the various steps that are, I gave you that link there. So copyright is pretty straightforward, that registration. A patent can be incredibly expensive. So you could spend, $20,000 just getting the application getting the non-provisional filed, and then to go through the prosecution could be, 100 plus. So, and again, it depends on how complex the technology is and how crowded that particular field is. But it doesn't depend on the size of the entity. It depends on the complexity of the particular IP asset that you're looking to register. Preparing for investor diligence. Ted gave some pointers on this, and the key is contract management. So make sure you are using good practices, make sure you get these things signed, and keep them set, easily accessible. You're going to want to have some kind of basis for your IP strategy. So for example, if you're using a ton of open source, you're going to want to have some kind of policy about copyleft open source. You're going to want to have something that says, hey, we have some folks overseeing what kind of open source, what kind of licenses are attaching to the code base, just as an example. When you go through that exit process, I can see some smiles about open source. You're going to be getting diligence questions where the potential investor will be saying, tell me what your policy is. Give me all your assignment agreements, those kinds of things. And keeping track of that is going to make your life considerably simpler.
Yeah, so educate yourself on the different open source licenses. Like 20 years ago, the word open source freaked out all investors. Any mention of open source, true. They all ran around in circles and got scared. Investors are more sophisticated now. They know good and bad open source, but you should know what that is too. He knows, I don't. Because what happens is if you have certain bad licenses, now that's another hole. Now that's a really major hole in your bucket, and a lot of water will leak out, and investors don't like that. So, like, you know.
Right, correct. And the key is just to have a policy. Yeah, go ahead.
So just when you say like have a policy, is this like, hey, we only use MIT license or something?
That would be great. You could even have a policy that says, hey, look, you know, we've architected the code so that if we've got a copy left, you know, we've got GPL v3 on this particular module, you know, it's not going to infect the rest of the code base. And a lot of it is simply oversight. You know, yeah, I'm sorry, go ahead.
Though it's perfect to never use that code. And it's better not to use that code. Because when to investor, the simpler the story, the better the story. So, you know, the best story is I don't have any open source. Well, congratulations, that ship has sailed.
Never going to happen.
That's not going to happen. So the next one is I don't have any, you know, bad copy left. And then they're like, okay, then all the attorneys, but not all the attorneys have the level of sophistication to understand the difference, how you can isolate copy left and then have it not contaminate. But that's a harder story. It's a more complex story to tell your investors. Investors like it simple.
That's right, simple, stupid. Okay, last thing, because we could talk about AI and have all sorts of fun, is keep in mind that when you go to register copyright, you can't claim ownership of things that aren't copyrightable, that can't be protected by copyright. And so the output of an AI engine, you know, there's this great Zarya of the Dawn case that the Copyright Office decided with Midjourney as the engine that generated, you know, this great graphic novel. You can't claim copyright protection from the output of an AI engine. So if you're relying on AI, you know, you're going to want to keep track of what your prompts were. You're going to want to try and pull apart what the AI engine generated for you versus what your own inputs were. Because if you're looking to enforce that copyright, you can't. There is no copyright in the pure output of an AI engine. So. All right, and Ted, I'll turn it over to you.
Yeah, I'm going to stand up because I can't read the darn screen, so I apologize. All right, people probably all heard on the news that FTC passed new regs and non-comps are dead, and so no longer are non-comps enforceable. So that was, you know, the big news in the spring. Well, unfortunately,
non-compete agreements.
Non-compete agreements. Unfortunately, that news is now not news anymore because things have happened. But I'll just go over just two levels here. I'll go over the FTC rules, and then I'll go over Massachusetts rules. So FTC, it's a very different approach to state law, because what they basically, state law says you cannot have a contract that says this, that restricts trade in these certain ways. The FTC says, well, actually what it is it's anti-competitive, and we, the FTC, have a right to enforce rules to keep you from doing non-comps in these certain ways. So they're restricting unfair methods of competitions, and any non-competition clauses with employees, you cannot put them in place after the law becomes effective. So for certain people, if they had pre-existing non-comps, they go away, and after the law goes into effect, you can't enter into non-comps at all with anyone. That was the FTC's proposed reg. And again, there is an exception if you are a senior executive, then in fact, you entered into a non-comp before the law went into place, a company could still enforce that with senior executives. I can go into the whole discussion, what's a senior executive? It's basically someone over $154,000 and who has a whole certain level of management. But as I said before, this is a fundamentally different structure than the state laws, because state law just says the contract's not enforceable. The FTC says it's antitrust and is subject to enforcement by the FTC. The hard part is, will this law ever go into effect? The regs were passed in the spring. The law was slated to go into effect on September 4th, but a court struck down the law from Texas on August 20, 2024. So the law, which was going to go into effect and would get rid of non-comps in a very broad sweeping way, was struck down in August. The FTC has appealed it. They had until the end of October, and in fact, they did file an appeal. to try and preserve the regs, but who knows what's going to happen. Presently, the Supreme Court is not a big fan in agencies issuing broad sweeping regulations. If you were a betting person, even if the FCC continues to try and appeal and get the regs put into force, if it ever gets up to the SJC, most betting folks are saying the Supreme Court would probably knock it down. So it is hard to know. Right now, the FTC rules are not in effect, and in order for them to go into effect, it would have to go all the way up basically to the Supreme Court and for them to say these rules are okay. That would be a long process. So all that news about non-comps being unenforceable effectively is dead. I'm not going to go into long discussions about that, but what you should do is keep an eye on this, keep an eye on the press to see what's happening with FTC regs, to see if the FTC's appeal gets heard and if they win and how far it goes up. But you might, some of my clients, they're afraid of the law going into effect, less so now. If I talk to my clients in August, a lot of them are running around having all their senior executives sign non-comps, trying to get the non-comps signed before the law went into effect. Most folks aren't doing that right now. And what you really need to do now is just follow state laws, because that's really what's going to happen. And when you say follow state laws, the question is, well, what state? And it can vary from state to state. I'm only going to be talking about Massachusetts. Each state has its own law about enforcement of non-comps. And some states like California really are very not permissive. Other states tend to be very permissive. So it just depends upon your state. And normally, again, this is a generalization, in Massachusetts, it's where you are resident. So if you are a resident in Massachusetts and working for a company in Texas, if you're a resident in Massachusetts, the laws relating to Massachusetts would apply to you for your non-comp. It will vary from state to state, but that's the general rule. So if you're a resident in Massachusetts the last 60 days, that's when it kicks in. So the general statement in Massachusetts passed a law, I think, in 2018, which kind of controls what happens with non-comps in Massachusetts. Generally, yes, they are enforceable as long as you jump through certain hoops and follow certain restrictions. First of all, non-comp has to be in writing. It must be signed by the company and by the employee. A non-comp also has to state that you have to warn the employee that they have a right to consult with an attorney before they sign it. So again, the Commonwealth of Massachusetts wants people signing it to be educated and informed before they sign it. They don't want people just willy-nilly signing away rights. Does it mean they have to talk with an attorney? No, but you have to notify them that they have a right to talk with an attorney. There are certain requirements about the timing. So what the state doesn't want you to do is to, offer an employment to someone and then 10 days after they start, they accept the offer to say, oh, by the way, here's a non-comp. They want you to give the non-comp along with the offer or 10 days before they start working. So there's some rules about timing of when you present it. Again, the state is trying to get rid of duress, so people have the full picture. Before you accept a job, you know what the restrictions are associated with the job. The next thing about them is not only have to be signed and presented in a certain way, the actual restrictions need to be reasonable. What you can't say is you can't do any type of work for anyone in the whole galaxy. What you need to do is it needs to be narrowly defined limited to protect the needs of the company. Again, two different views on this. If you're thinking about this as an employee, then you want to have a very narrow non-comp. If you're an employer, you want to have as broad a non-comp as you can, but Massachusetts says, yeah, it can't be too broad. It has to be specified for the specific purpose. It has to be, protecting your trade secrets, try and keep things confidential that otherwise would not qualify, and protect the company's goodwill. The basic thing Massachusetts is looking to say, listen, they want companies to spend money to develop IP, and they're willing to let you protect it. And so if it is necessary to protect your IP, to have a non-comp, Commonwealth of Massachusetts is okay with that, but they don't want it overly broad. It cannot last over 12 months, except there are some restrictions. If you are fired for cause, it could be the non-comp could extend as much as 24 months.
Did you have a question?
Oh, yeah. I was since each state has their own representation of the non-comp, can you challenge it if you try to compete outside of the state?
If you what?
If you try to challenge them while you're not in the state.
No, so if you live in Massachusetts and you're employed by a company in California, Massachusetts would say Massachusetts law applies. So you would look to Massachusetts law to see whether or not the non-comp. If you look at California and say, oh, that's even better, no, and that says you're probably stuck with Massachusetts. And you'll see sophisticated companies will have different forms of non-comps depending upon where their different employees work. Some companies have just realized it's a nightmare trying to figure out the specifics, and they don't actually have non-comps, and I'll come around to that towards the end. And it has to be geographically restricted, which is if you're only doing probably less in this industry, less applicable because you're probably not geographically limited in what you do. Your products are probably available nationwide and internationally, so the restriction may not. But it has to be in an area which the employee worked in the last couple of years. And it has to be limited activities that you provide. And this is probably the most important one for employees, which is you can't say, if you've been doing X, the non-comp can't say you can't do X and Y. It can only say you can't do X. So it's the type of work you've already been doing, you're limited in doing that again. That's a big one because a lot of companies would say you can't do anything we, the company, do. And in Massachusetts, it can't say that. It has to say you can't do anything that you did for the company in the prior 2 years. And it can only apply to higher level employees. It can't work for hourly. Exempt is basically hourly employees. So if you're getting paid hourly, like your receptionist or your lower level clerk, is not required. And again, that's the concept is they're not working on things that are sophisticated. Therefore, you shouldn't have them sign non-comps. They should be freely work wherever they want. Massachusetts is trying to thread the needle between encouraging growth in companies as well as encouraging employment and allow free employability of folks. And each state threads it a little differently. And this is a big one. If you're fired or laid off, if the company terminates you, your non-comp doesn't apply. The concept being, well, if you didn't want the employee, then the non-comp doesn't apply. If you as an employee just quit, okay, the non-comp applies. Or if you employee are fired with cause, the non-comp applies. But if the company lays you off or terminates you so you want to continue working, but they won't let you work, then the non-comp doesn't apply in Massachusetts. It has to have consideration. Yeah.
What if you quit and then they forgot to give you the non-comp, and then they're like, oh, can you sign this before you leave?
So that is actually a separate situation. And the answer is those can be enforceable, but you don't have to sign that. I mean, they can't force you to sign that at that point.
Unless they give you a big check.
Well, that's the thing. So the non-comps, and you see a lot of these restrictions don't apply in that scenario, which is interesting, which is these are all talking about non-comps they make you sign when your first day of work, or before you start working there. But if you were to have that situation, they said, oh, crud, we didn't get a non-comp. Then they would come to say you'd sign this, and you'd say, looks great, what's it worth to you? And then, at that point, you're negotiating. You don't have to sign it. You have leverage. And the Commonwealth of Massachusetts says you could agree to a 20-year non-comp at that point if you wanted to. I mean, you'd only do it if they gave you enough money. But now it's kind of free negotiation. You're not stuck. So the Commonwealth is actually okay with that concept. They have to have consideration, and consideration means you get something of value for it. There's a safe harbor that you may have seen in non-comps today, which is basically what they call garden leave, which is if the non-comp is only enforceable if they pay you 50% of your salary during the non-comp period. That's just a safe harbor. The law is not really clear exactly what is considered. It says consideration. It says this is definitely consideration. Is 25% of your salary enough? Is some stock options? Is a cash payment? It is up to, it depends on how much risk you want to do. But a lot of companies will use the safe harbor because they know that works, and then they have a good non-comp. Yeah.
Could you negotiate that and just be like, well, just pay my taxes for, this year or something like that?
Yeah, again, so this agreement is signed the day you start working, not when you're quitting. So you can negotiate, whatever you want. It's how comfortable the company is. The company is going to want to know they have a good non-comp. So a lot of companies will default to this. But they may be more aggressive and say, okay, yeah, we'll pay you $50,000, or we'll pay your taxes, or we'll do something else. They'll hold their nose and hope that the courts will find that to be adequate consideration for the non-comp. My employment attorneys would hate that because they love the safe harbor. Mere continuation of employment is not sufficient. So like if they came to you in the middle, this is an issue in a lot of states, which is they didn't have you sign a non-comp day one. And so you've been working for 2 years and they come around and they're about to sell the company, and the buyer says you need to get non-comps from everyone. And then they come to you and say, okay, we'll give you a non-comp, sign it. And you say, what's it worth to you? And you say, well, we won't fire you. And the answer is no, that's not adequate consideration. There has to be some amount, something paid to you for it.
Can they fire you for cause if you say, I'm not signing this?
No. That would not be cause. They can fire. Remember, for the most part in Massachusetts, you're an employee at will. They can fire you whenever, but it would be without cause at that point. When are the restrictions not applicable? If you ever end up selling a company, in theory, you'll get a pot of gold, and when you get that pot of gold, that will also come with a non-comp. And Massachusetts says all of these restrictions are really in an employment context, not a sale of a business context. So if you go out and sell your business, every buyer will acquire a 3 to 5 year non-comp because they're paying you X $1,000, and that is enforceable. And all these rules I just mentioned don't apply to a non-comp signed in conjunction with a sale of business. It's a little weird as to figuring out, if you only own 0.001% and you got $50, can they make you sign a non-comp then? Because that's when you get into is it a significant owner, or will you see significant consideration? But if you're getting a good penny, and most likely to be enforceable. And this is the one you mentioned, which is non-comp signed when you terminate your employment. Those are open for fair negotiation, and the parties can agree to them. Very interesting, a lot of transactions I'm doing with companies which have operations in all 50 states, they will not some of them don't have specific non-compete. So they'll have a restrictive covenant agreement signed by the employees, but it will not say you will not work for competitors for X years. It'll have something else. It'll have a confidentiality clause, which basically says you'll keep everything you learn confidential. They'll have a non-solicited employees clause, which says you won't solicit any of the employees once you leave the new employer. And they'll also have you won't solicit vendors or customers. And that's the last one, is kind of like a non-compete, right? It's basically saying, I won't go back and talk to the people I worked with while an employee of yours. I won't go back and talk to those people. I won't try and take work away from you. In Massachusetts, non-solicited customers is enforceable. That's not considered a non-compete. It means I can go and work with a competitor, but while working with that competitor, I can't go back and solicit all the customers that I met while working with you. So those are enforceable. And I don't know if we want to try to cover that quickly. So any questions about that?
If you go to a separate company and that company then separately of yourself goes and works with a past contact that you had, I guess is that really just like a gray zone, where it's just like, well, I had no input on this new company that I'm at reaching out to this past customer, and yet we're still doing that. Does that impact the non-solicited customers?
So again, the non-solicit is really affecting your behavior, not their behavior. It doesn't go upstream and say, we won't chase your past customers. So it would really be limiting you, not them.
But it is the case that if you're hiring someone, so I'm going to be I'll hire Chris, and I may want to ask Chris, do you have a non-compete? Do you have a non-solicit? What are your confidentiality obligations to Ted, your former employer? Because I can be responsible if Chris has got these obligations and he's doing all sorts of crazy things. I may be tagged with that wrongdoing. So there is a potential upstream concern that would be part of your questions for the new employee.
When you hire people, it's
When you
part of
hire
your
people.
diligence.
Yeah.
Most onboarding say, are you subject to any confidentiality or non-competition agreements? And then if you are, they want you to present them. So they won't take your word that you're okay.
Exactly.
Usually they want to see it, and in some cases they may actually go back and try and get a waiver or something, or as clarification from the prior employer, or try and negotiate a release from the non-comp. We see that.
We went a little over. We're very happy that you all were interested to listen to these legal topics. We're happy to hang around for a few minutes if anybody else wants to come up with questions. Thank you very much. Please come up.
Yeah.
Thank you very much.
Yeah.